Bhaskar Rao, as a citizen, not just as a police officer, but as a citizen of Bangalore, do you feel the anger that the Supreme Court seems to have expressed against the Karnataka High Court today? Because essentially the sense is that if it is you and me, maybe not you because you're a former police officer, but if it is any common citizen, if it is me, if it is Mithun Kumar, it will be Tariq pe Tariq, Tariq pe Tariq, Tariq pe Tariq. We will not get bail. But for someone like a Darshan, but someone like a Ram Rahim, bail pe bail, very easy. You will get bail for anything. You will get bail to party in Thailand. You will get bail to cut your birthday cake with a sword outside.
The language of the Supreme Court of India is extremely pleasing to the common citizens of India because it has used such strong words against the High Court of Karnataka. Till now, we all always had highest respect. Of course, barring a few good judges who are balanced. This entire bail, interim bail and regular bail, it looked as if the entire High Court was sold out to Darshan, and the Supreme Court's argument and what the Honorable CJI and also what the double bench has mentioned is a great eye-opener. How the High Court judge has casually given away bail casts a huge question of the integrity of the High Court of Karnataka itself over there. And as you rightly mentioned, everybody has got tariq per tariq and these people enjoy bail per bail, but it has definitely lowered the image of the High Court of Karnataka in the eyes of the citizens of Karnataka. We always used to hold it in such high respect that this is a temple of justice. But from the very beginning we knew that this person, Darshan, who after having committed such a ghastly crime, thanks to the initiative, though I'm in BJP, the local government has ensured that the Congress government ensured that proper investigation is carried out and no compromise needs to be done, and it gave a free hand to Chandan, the investigator, to charge sheet this case. And when the bail was given here, it rightly approached the Supreme Court for the cancellation of the bail. I think justice has been done for the common innocent citizen of Karnataka, and Karnataka High Court judge, whoever it is, has literally been exposed, and he has brought down the image of the court in the eyes of the people.
I'm not sure justice has been done given the fact that the guy is accused of murder. He's out on bail. He was found to be smoking in jail, being treated like a VVIP, and on bail right now he's in Thailand partying.
That's what I'm telling you. His bail, he's on bail, and whatever the Supreme Court has mentioned, that's what I'm saying, that it offers a ray of hope to us that at least there is someone much above the High Court who can ensure the rights of the common citizens.
Sanket Yenagi, the Supreme Court called this a perverse exercise of judicial power. Do you agree with it?
Yes, I agree with the observation of the Supreme Court. Wherever the High Court or the courts below, whose judgment or order are under scrutiny before the Supreme Court, Supreme Court is examine or judicially review the entire order and the application of a mind by the judges of the High Court in respect to the facts and circumstances of the case and the materials available on record and the seriousness of the allegations and the social impact as well. So it is not just that some argument has been made, some technical points have been urged, and that needs to be given a go-by to every principle which has to be considered at a particular point of time. Because the social impact which the case has, or the impression it is going to have in a common man, or the culprits who would also perpetuate the same or similar offences, they should be taught a lesson. The intention of the legislation is not just to curb the crime, but also to see that others be prevented from committing such offences. And the bail is a rule and jail is an exception though, but not in all the cases of this nature, where there is a serious allegation pertaining to abduction, offense pertaining to commission of an offense pertaining to cold-blooded murder, destruction of the evidence of these witnesses or influencing the witnesses. This is not a casual case or the casual manner in which the exercise of the discretion be made in a casual way. So, in my personal opinion, there are three important aspects. One is lack of judicial application of mind by the High Court, which was considered by the Supreme Court. Number two, bail order is resembling almost like an order of acquittal. So that is also one of the points the Supreme Court has considered. Third one is mistakes in reasoning. The reasoning which was given by the High Court is not appropriate or not in tune with the evidence of the materials placed in the charge sheet. That is one of the point. And the likelihood of cancellation of bail could be on multiple reasons. Number one, it could be like interference with the process of trial because of the influence which he carried.
Okay.
And other witness intimidation or influencing the witnesses or obstruction to the justice. So, Sarah, there are certain medical records placed before the court, if you may remember, claiming that he requires immediate surgery. If I may say so, the point which was made out before the court, or which was convinced before the court almost, with certain documents, that there is a medical emergency for which reason he needs to be granted a bail. There need to be an immediate surgery. But where is that surgery now?
Correct.
These are all the
In
things
Thailand, that surgery is
which may
happening
lead
there.
to certain conclusion.
Sir, that surgery is happening in Thailand. It's on your screens. I don't know what kind of surgery is this. Aditya Pratap